今天很感谢这个深圳国际仲裁员，还有华南香港国际仲裁员的邀请，有机会来到这里跟大家分享一下有关于香港的普通法的一些基本的简介。我希望你们看到我的现在的荧幕分享哈，如果看不到的话就告诉我。那今天的课程大纲呢，我们分3个部分。第一个呢就是法律的原则，第二个呢是法律的分析，还有第3个呢是事实的分析。因为今天的主题呢是要讲有关于普通法，所以呢我觉得呢用英语来讲呢可能比较原汁原味哈。所以呢，我现在开始呢就用英文来跟大家讨论分享。如果有不明白的或者有问题的可以在我讲完以后呢大家提问欢迎大家把什么不明白的或者讲得不清楚的都可以问我。So the first thing is we want to know what is meant by the common law. So the common law is basically a case law or judge-made law. The special features about judge-made law is that it is not based on statutes. It is not based on expressly written law made by the legislature. If we look at the historical origin of the common law, it started in the 11th century in England. Now, from that moment, the common law developed in England and spread to other parts of the world as the British Empire started to govern many parts of the world. Now, as of today, many countries are based on the common law system. They include Hong Kong, which is part of China, and also places like 49 out of 50 of the United States of America, the UK, and also places like Australia, Singapore, and Malaysia. Now, of course, the common law is not the only legal system around the world, and the common law is to be contrasted or to be differentiated from other types of law. And here we have 3 types of law, which I have put on the screen. Now, the first type is constitutional law. Now, constitutional law refers to the constitution of a country. And in the case of the Hong Kong Special Administrative Region, we have our own mini constitution known as the Basic Law. Now, other than constitutional law, we also have something called statutory law, which is, as I said, those statutes or legislation made by the legislature of each region or each country. In addition, we also have something called executive regulations. These are regulations or rules made by the government or departments of the government for administrative purposes. So when we speak about the common law, sometimes we use that expression to differentiate it from constitutional law, statutory law, and the executive regulations that I have mentioned. In another sense, when we speak of the common law, sometimes we use that expression to contrast it with civil law or civilian law. Now, what's the difference between the common law and civilian law system? Under the common law system, as I said, case law is the most important part, and the function of case law is to fill in the gaps left by statutory law, because statutory law, by definition, is relatively brief and relatively short. So whenever there are some areas that are not expressly dealt with by statute, or where some of the wording of a statute is unclear, this may lead to some litigation. And in litigation, the courts will make a decision or pronouncement on the meaning of certain words in the statute. So this is another characteristic of the common law system. In other words, whenever there is only where there is a dispute, and only where the disputing parties take the case to the court and settle the dispute by a judge of the court, will there be a decision or pronouncement by the court. Now, another important feature of the common law system is the adherence to the doctrine of precedent. I will explain what this means in the next slide. But comparing the common law system, which, as I said, is something that we inherit from the British system, there is another system called the civil law system, which is based on continental law in Europe. So in countries such as France and Germany, their law is not based on case law, but it is based on codes. So here we call this kind of laws or legislation code or codified law. So for example, in those countries, you may find all the contract law being written out in a set of rules in a piece of legislation. But that is not the case in the common law system, where, for example, most of the contract law is based on judge-made decisions. So in a civil law system, in general, the courts would feel that they are authorized to decide a matter only if the matter is governed by a statutory provision. And if there's no statutory provision, they might feel that they are not empowered to act in a particular way. So let's now look at some more of the important features of the common law as we have it in Hong Kong and other parts of the world. So the court's main job is to give an authoritative interpretation of the written law, such as constitutional law, such as statutory law, and as I try to explain, they also fill the gaps where these laws do not provide an answer. Now, one of the reasons why the common law has gained such popularity around the world, not just by governments and not just by business people, but also by people engaged in arbitration, is that it is very flexible. It is very flexible because it is up to the judge to make a decision based on the facts of the case and on previous decisions, which we call precedents. Now, very often we find that a judge will feel or will be able to justify a particular decision by reference to a precedent. And sometimes, if the facts are different, the judge will say this precedent can be distinguished and therefore make a new decision. Now, another common feature or important feature of the common law system is that the courts, when they make a decision, usually they will give detailed reasons why they have decided a case in a particular way. Now, this is important because it will give more confidence to people who are involved in a dispute, because they would know why they lose or win a particular case. It is also important because the losing party can look at the reasons, and if they disagree with the reasons, they can appeal the decision to a higher court. Now, I will come back to the system of hierarchy in terms of the courts in the later slide. Another feature of the common law is sometimes said to be its evolving nature. In other words, it is constantly evolving in order to meet the changing needs of society. So when we say that the common law goes back, for example, to the 11th century or the 10th of the 10th century, it does not mean that the common law has not changed at all for the last 900 years. On the contrary, the judges, through developing case law, are constantly and actively changing the law in order to meet the needs of daily life. For example, the advances of technology, and also the different needs of society at different times. Finally, I come back to the doctrine or the principle of precedence. Now, the Latin expression for the doctrine of precedent is stare decisis. It means the observance or the adherence to past decisions. Now, to break it down a little bit, it means several things. The first element is that a court is bound by a previous decision made by a court of a higher, and in some cases, of the same level. Now, the importance of this doctrine of stare decisis is that it ensures that judicial decisions are certain, are consistent, and predictable. So that in civil cases, for example, business people can go about their commercial dealings with the knowledge that their disputes will be decided in a certain way. And more importantly, in criminal cases, it means that people can know the boundaries of legal and illegal behavior so that they will not be caught unawares. And this is, of course, important because criminal cases involve the liberty of the subject, and people who break the criminal law can risk going to prison or be fined. Now, when we talk about the doctrine of precedence, we have to be careful because we are not talking about a particular set of facts. We're talking about a legal principle. So only the legal principle laid down in an earlier decision forms part of what we call the ratio decidendi. And in other words, the essential reasoning that leads to a particular decision. And it is that legal reasoning, the essential reason for the decision, that becomes binding on subsequent cases and subsequent courts. Now, sometimes we use this Latin expression, ratio decidendi, in contrast with another Latin expression called obiter dicta. And the latter expression refers to some side comments or reasons that are not essential to the decision of a case. So when a judge looks at a precedent, a past decision, he will have to, first of all, find out what was the ratio decidendi of the previous case. And he must disregard, or he would not be bound by the non-essential reasons called obiter dicta expressed by a previous court. Now, that doesn't mean that he cannot follow the obiter dicta. It simply means that he is not bound to follow them because they do not form the essential part of a previous, the essential part of the decision of a previous judge. So if you remember a while ago, I mentioned very briefly the fact that a decision can be appealed to a higher court. So in most common law systems, and I believe also, for example, in mainland China, there is a 3-tier appellate system. So taking Hong Kong Special Administrative Region as an example, you see this in this diagram, the lowest in the lowest part of the picture, there's a district court and lands tribunal. So the lands tribunal is a specialist tribunal that only deals with disputes involving land ownership or tenancies. Now, the district court is a court of general jurisdiction, but limited by a monetary amount, which currently I believe stands at 7 million Hong Kong dollars, something like that. Now, if the monetary amount of the dispute is higher than that, then one has to start a case in the court of first instance, which is part of the High Court of Hong Kong. So for criminal cases, there is a similar distinction between criminal offenses that are of less serious nature and those of more serious nature. But today, let us focus on civil cases rather than criminal cases. So those 3 tribunals are what we call first instance tribunals. In other words, if a case is started, it has to start in one of those 3 places. So the judge sitting in one of those 3 places is a first instance judge. He makes decisions of law, and he also makes decisions of fact. Now, I will not mention the competition tribunal for the purpose of tonight. It is another specialist tribunal, but it is a very young and very new establishment. Now, from those 3 or 4 first instance tribunals, the losing party can appeal to the Court of Appeal. And from the Court of Appeal, the decision can be appealed to the Court of Final Appeal. So essentially, there are normally 3 layers and 3 tiers of decision makers. Now, in terms of the doctrine of precedent, how does this operate, or how does it fit into the hierarchy of the 3-tier court system? Now, looking at the court of first instance first, so court of first instance includes a district court and lands tribunal. Because they are the lowest in the 3-tier system, the courts of first instance are bound by decisions of higher courts. In other words, the Court of Appeal and the Court of Final Appeal. Now, they are not usually bound. They're not bound, I should say, by decisions of another court of first instance. Unless, for example, you're talking about a district court. A district court decision, a district court judge is bound by a decision of the Court of First Instance because it is in fact regarded as a higher court than the district court. Although in terms of hierarchy, they should really belong to the same entry level. But as I mentioned, there is a difference between those 2 courts in terms of the monetary ceiling of the civil claims that they can deal with. So if we go up 1 rung in the ladder, we go to the Court of Appeal. Now, in the Court of Appeal, the court usually sits in a panel of 3 judges as opposed to 1 in the lower courts. Now, the Court of Appeal is bound not only by the decisions of the Court of Final Appeal, but also by its own decisions. But there is an exception to that rule. And that exception applies when the Court of Appeal thinks that a previous decision made by itself or another division of that court is plainly wrong. So the test is whether the previous decision is plainly wrong. Now, this is a very difficult test and a very high threshold to meet. Usually what it involves is that the previous decision either overlooked a relevant piece of legislation, or that it overlooked another previous decision by which the Court of Appeal was bound. Now, let us finally take a look at the Court of Final Appeal. Now, the Court of Final Appeal sits at the top of the hierarchy. It can only depart from its own decisions in very, very rare cases. But it does have the power to change the law by departing from previous decisions. Now, those occasions are very, very exceptional. It has happened before, but I think it is fair to say that it involves, for example, a radically different changed set of circumstances, or a new understanding of the law that has gained acceptance in other parts of the world, for example. So that is the first segment of my talk. And next, 下来呢，我们要看的就是法律方面的分析。OK， 这个部分呢，里面我会看的就是明文法的传释，还有案例的搜寻，阅读案例，还有明文法例的方法。Okay, so the first topic is about statutory interpretation. So statutory interpretation means the interpretation, or sometimes we use a different word, which is the same thing, construction of a statute. Now, the purpose of the exercise is to look for legislative intent. Now, sometimes when a judge says the legislature intended to say something or meant to say something, that is showing that the judge is looking at the words of the statute to find out what the legislature means when it enacted the law. But what does it exactly mean by legislative intent? Now, it is not the subjective intention of the lawmaker, but rather the intention which the court can reasonably and objectively impute to the legislature in respect of the language used. So, in other words, the court looks at the words and asks itself what the legislature meant when it used that language. So in order to carry out this particular task, which is very important, the court uses or employs certain aids or rules of interpretation. I will explain some of those in a moment. But in general, there are two types of rules of interpretation. That the first type is statutory, and the second type is some rules of interpretation that are found in the cases in the judge-made law. So for statutory rules of interpretation, the most important one that we have in Hong Kong is found in Section 19 of the Interpretation and General Clauses Ordinance. It is quite a very long name for this statute, and we will sometimes shorten it to IGCO for simplicity. It is Chapter 1 of the Laws of Hong Kong. So the wording is here stated on the slide. An ordinance shall be deemed to be remedial and shall receive such fair, large, and liberal construction and interpretation as will best ensure the attainment of the object of the ordinance according to its true intent, meaning, and spirit. So in other words, when the court looks at the wording of a statute, it must do so bearing in mind the object, i.e. the purpose of the ordinance, the statute. And having found out its object, for example, it is to deal with a particular kind of crime or to deal with a breach of contract, that being the object of the law, the court then then finds out or decides what interpretation it should give to the words in order to give it a large, fair, and liberal construction. So in other words, it is a purposive approach to the construction of a statute. Now, let's now turn to another source of the rules of interpretation. And as I mentioned, that is the set of rules developed by the courts themselves as a guide to interpretation of statutes. So there are several general principles which are often followed and often said to be the key principles. The first one is that the court must construe the relevant words with regard to two things, context and purpose. So we have already seen the place of purpose in section 1 of the Interpretation and General Clauses Ordinance. Now, but what about context? Now, what context means is that the court will look at everything, everything, including the words themselves, but beyond the words themselves. In the very wide sense, it includes provisions of other provisions of the same statute, the legislative history leading to the enactment of the statute, and any subsequent amendments made to the statute. Now, the court will also find out, if it can, the purpose of a particular enactment or a particular statute to provide context and to guide its search for the meaning of the words that are used in the statute. Now, in Hong Kong, we're in a very unique position in the common law world with regard to the use of language, because Hong Kong has two official languages, English and Chinese. You can imagine there may be some statutory provisions that are bilingual, but the Chinese text and the English text may differ. The legislation has provided us with some guidance on the method of resolving any differences between the two languages used in a statutory provision, and we'll look at that in a moment. Now, coming back to the general principles, the last one that we find that is quite commonly cited is that statutory interpretation must be flexible and open-minded, in the sense that the court may find the purpose of the law in the provision itself. It can also find the purpose of the law in what's called the explanatory memorandum, or the official statement that accompanied the bill. Now, to explain that, one has to understand the process of legislation in the Hong Kong Special Administrative Region, and that is to say, when the government proposes a bill in the Legislative Council, it will go through several stages of debate and screening. But in the first place, when the government promotes a bill, it will be accompanied usually by a statement of explanation, and that is the explanatory memorandum. And in the explanatory memorandum, we would expect to find a statement of the problem that the statute seeks to address, and an explanation of the solution, or the proposed solution to that problem. So if the court is in doubt about the meaning of a particular word in a given legislative provision, it can look at the explanatory memorandum, or the official statement that was given by the minister or the government official promoting that bill. Now, just now we have seen both in the IGCO and also in the case law, the emphasis on purposive interpretation, that is to say, a search for purpose or context, but there are some limits to the weight that the court can give to the purpose. So one of the rules is that the court must not distort or ignore the plain meaning of the text. So if the text says black, the court cannot say it means white, even if the context or the purpose may indicate that. Secondly, the court must not give a provision, a meaning which the language understood in the light of its context and purpose cannot bear. So the example I just gave also falls into this category. So therefore, there are two parallel rules. One is to look at the purpose and context, and the other is to obey the meaning of the text. Now, between these two rules, there are many different situations, and there is no limit, or shall we say, there is no particular way of predicting how a court would choose one rule over the other in any particular case. And that, in a way, is an expression of the flexibility of the common law. Now, all that is seems a little bit theoretical. I would like to share with you an example, a very recent case. This is a case I think only published a few months ago by the Court of Final Appeal in Hong Kong. And in that decision, called HKSAR versus Chan Chun Kit, the court decided on the meaning of a very old statutory provision to do with public order. So let me just give you some of the facts of the case. So in the wake of an unauthorized assembly in 2019, the defendant, I say D here, was among a group of onlookers wearing a black outfit, a black face scarf, gloves, and a black backpack. So those of you who watched the news at that time may know that Hong Kong was in a bit of trouble. And there were a lot of young people who wore this kind of outfit in order to demonstrate their unhappiness. So in the backpack, the police found, among other things, 48 pieces of 6-inch plastic cable ties. So these are white bits of white plastic that can be used to tie together the metal railings that you can see in the picture here. So when the police questioned the defendant, Mr. Chan, he said or rather they found out that he intended to use these plastic cable ties to bind detached metal railings on the road in order to form barricades for use in either armed confrontations with the police or for blocking the road. So that was how he intended to use those bits of plastic. Now, in the magistracy court, which is a first-tier court in Hong Kong for minor offences, he was charged for an offence under Section 17 of the Summary Offences Ordinance. Now, the Summary Offences Ordinance is something that goes back to something like 1856 in Hong Kong. So it's a very, very old statute. But being a very old statute, it has also undergone a lot of changes in the last 100 years. Now, in the current form, Section 17 reads as follows, and please be a little bit patient. I know there are a lot of words, but this case is part of the fun of this case. It comes from the fact that there are so many words in Section 17. So what it says is, any person who has in his possession any wrist restraint or instrument or article manufactured for the purpose of physically restraining a person comma, any handcuffs or thumb cuffs, comma, any offensive weapon, comma, or any crowbar, picklock, skeleton key, or other instrument fit for unlawful purposes, comma, with intent to use the same for any unlawful purpose, comma, shall be liable to a fine or imprisonment. Now, so you see a very long string of words here, separated by several commas. And at the beginning of each group of words is the word any. And between all these different types of articles, the legislature has separated them by using the word or. So after a list of these instruments or articles, there is then added the mental element, or what we call in Latin mens rea, that is the mental element needed to establish criminality. In here, it is intent to use the same. The same refers to any of the above instruments for any unlawful purpose. So to break it down a little bit, this criminal offense is committed by someone who has in his possession any of these articles or objects together with an intention to use the article or object for any unlawful purpose. Okay. So as I said, the case first went to the magistracy and the defendant was convicted. Now, the difficulty in this case was that the cable ties may fall within the first category of articles made for restraint or physically restraining someone. Now, but that is not the purpose for which Mr. Chan had intended to use the cable ties. He had intended to use the cable ties to tie up the metal railings on the side of the road, and not in order to tie the hands of somebody. So let's look at, first of all, the first instance decision. The unlawful purposes for which an instrument was fit, this is the magistrate's decision, okay, must be related to physically restraining or injuring a person or housebreaking. And insofar as the mens rea, the mental element is concerned, he said that the unlawful purpose for which the defendant intended to use the offending instrument could be any unlawful purpose and need not be related to restraining, injuring, or housebreaking. Now, we may have to go back to the wording in a moment, but you remember that the unlawful purpose or unlawful purposes were mentioned twice in section 17. And here, the magistrates gave an interpretation of what that expression meant. Okay, let us go back to the legislation. So first of all, we see that any person in the first group of articles, any wrist restraint or other instrument or article manufactured for the purpose of physically restraining a person, any handcuffs or thumb cuffs, any offensive weapon, or any crowbar, picklock, skeleton key, or any other, or other instrument fit for unlawful purposes. So that is the first place where unlawful purposes appeared. So according to the magistrate, these unlawful purposes must relate to the activities that are mentioned in the first 4 lines of the legislation. So either for restraining somebody physically, or for housebreaking, as in the crowbar, the picklock, or the skeleton key, or an offensive weapon that is, of course, used to hurt another person. So when the magistrate looks at this expression, unlawful purposes, in the 5th line, he interpreted it to mean those purposes that those instruments are capable of. So that's the first point. The second point of his decision was that the intent to use those instruments for any unlawful purpose, does that relate to the previous unlawful purposes, or it can be any unlawful purpose? The magistrate said it was any unlawful purpose, and it does not have to be the same unlawful purpose for which the instrument is fit. So that is how he interpreted, at the first instance, the rather long and complicated wording of Section 17. So in so doing, he convicted the defendant because even though the cable ties were fit for physically restraining another person, and although the defendant did not have that in mind as his intention, he said that the second unlawful purpose does not actually have to relate to the first unlawful purpose. It can be anything. And in this case, he was intending to obstruct the public highway, and that was enough. So the defendant took the matter to the Court of Appeal. Now, it is very interesting to look at the decision of the Court of Appeal. The Court of Appeal upheld the decision of the magistrate. And it did so on for slightly different reasons, which we will see in a moment. But the interesting point about this case is that the Court of Appeal looked at the Chinese text of the legislation, which is different from the English text. Okay, so let's look at the Chinese text. 任何人管有任何网拷或者其他触拨人身而制造的工具或物件，或管有任何手铐、齿铐、攻击性武器，这个我不会读，什么工具，百合石或者其他适合做非法用途的工具，意图将其做任何非法用途使用，可以科处第2级的罚款或者监禁2年。Okay. So the Court of Appeal looks at the Chinese text, which is different from the English text. And he said, or the Court of Appeal said, the first unlawful purposes, i.e. the 非法用途的工具 in the 4th line, can be any purpose. And the Court of Appeal said that the magistrate was wrong in saying that those unlawful purposes must be related to housebreaking, restraining, or attacking another person. Now, and when the Court of Appeal looked at the 非法用途 in the 5th line, they agreed with the magistrate and said that, well, the 非法用途 can be any unlawful purpose, and it's not restricted to any purpose for which the article is fit. So in looking at the Chinese text, they said that, well, because in Hong Kong, we have a rule saying that the Chinese text and English text are deemed to be equally authentic. They chose to rely on the Chinese text over the English text. Then the case went up to the Court of Final Appeal, and this is the most interesting case I think we've had for many years on statutory interpretation. So in the Court of Final Appeal, and by the way, there are 5 judges who sit in each case in the Court of Final Appeal. The judges traced the origin of Section 17 to 1844, when it was first enacted. And it also looked at all the case law over 160 odd years of the history and to see how previous judges had decided on the meaning of the words. Now, the law, as I said, had undergone in those 150 years a number of changes in the English text. We'll come back to the Chinese version in a moment, but even the English text had undergone a series of changes, and I'm not going to go through all of them with you tonight. So let's just focus on the present version of the English text for this discussion. Now, as I said, the court looked at all the past decisions on Section 17 and what it means as interpreted by previous courts. And they found that in all the previous decisions, the courts in Hong Kong have given the section a very restricted meaning. And the restriction comes from the application of a rule called ejusdem generis. So again, this is a Latin term, meaning that whenever there is a list of items, for example, A, B, and C, or X, Y, and Z in this illustration, and if X, Y, and Z belong to a common genus, genus means a type. So X, Y, Z, and other items. So if, for example, that's the phrase used in the legislation, then the other items, being the general words, are taken to be restricted to matters of the same limited character. In other words, when the legislation says X, Y, Z, and other items, it doesn't mean anything. It doesn't mean A, B, C, D. Those other items must belong to the same category or same type. And here, using the word genus, and be given that restricted interpretation. Okay, so this is a rule of interpretation that goes back for a long, long time. And the name given to it is ejusdem generis. So how does that rule apply to the English text in Section 17? We'll come back to the wording and take a look at it in a moment. But as far as this rule is concerned, it is only a presumption or aid to construction. So if there is a contrary intention that is expressed by the legislature, that presumption can be rebutted or disproved. So how did the Court of Final Appeal apply the ejusdem generis rule? So if you can still recall the list of instruments in the current version of Section 17, there are really three categories. The first category refers to instruments that are used for restraining another person. So any wrist restraint or other instrument or article manufactured for the purpose of physically restraining a person, any handcuffs or thumb cuffs. Okay, so that is quite easily understood. And the second category, on its own, three words, any offensive weapon. Now, an offensive weapon obviously is used to attack or to injure another person, serving a different purpose from the instruments listed in the first category. And then finally, in the third category, those things that are used by thieves and robbers to break open a house or a car or any enclosed space. And the words in the section are any crowbar, picklock, skeleton key, or other instrument fit for unlawful purposes. So it is the focus of the decision is on that expression in the third category, or other instrument fit for unlawful purposes. Now, applying the ejusdem generis rule, the court held that the expression other instrument fit for unlawful purposes is not just any instrument fit for any unlawful purpose, but instruments that are like crowbars, that are like picklocks, and that are like skeleton keys, in that they are or can be used to break open a house, a door, or a car. So in other words, an instrument fit for the purpose of gaining unlawful access. So the Court of Final Appeal held that there is a restricted meaning or limited meaning to the third, to the general words in the third category. Now, turning to the mens rea, i.e. the mental element, you remember that Section 17 specifies that the defendant must have an intent to use the instruments for any unlawful purpose. So those are the words we saw before in the English text. And the Court of Final Appeal said, well, any unlawful purpose does not really mean any unlawful purpose, because this phrase appearing after the categories, the three categories of instruments, must be read again in a restrictive way. And it takes its meaning from the context of the uses and purposes of the instruments and articles set out earlier. So the mental element that the prosecution has to prove in respect of the intended use must correspond to the actus reus, in other words, the physical element of the intended uses of the articles and instruments. So in other words, going back to the three categories, if a defendant is charged for possessing a wrist restraint, handcuffs, thumb cuffs, the relevant intention is to use the wrist restraint or handcuffs or thumb cuffs to restrain someone. So it cannot be to use those instruments to, for example, to tie together the metal railings on the side of the road, because to do so would be to decouple or unlink the actus reus and the mens rea. So in the second category, being offensive, any offensive weapon, the corresponding mental element that the prosecution must prove is an intention to injure another person with that weapon. And likewise, in the third category, if a defendant is found to be in possession of a crowbar, picklock, skeleton key, or other instrument fit for gaining unlawful access, then the prosecution must prove that the person actually intended to use that instrument in order to gain unlawful access. Now, because of the way the statute is interpreted by the Court of Final Appeal, the result was that the defendant, Mr. Chan, was acquitted, because although he did possess an instrument that's capable of being used as a wrist restraint, that's not his intention. He didn't intend to use them to tie anybody up. He was going to tie together those metal railings in order to block the road or to form a barricade to fight with the armed police. And therefore, on the proper construction of the Section 17, the Court of Final Appeal decided that Mr. Chan must be acquitted. Now, how did the CFA, the Court of Final Appeal, address the issue thrown up by the Court of Appeal, which, as we saw, relied on the Chinese version of the law? So let's go back a little bit to the history of the Chinese legislation. So what happened is that in the early 1990s, in Hong Kong, the government started to realize that the change of sovereignty was going to happen very soon. and it decided that all the laws that until then had only existed in English had to be translated into Chinese. So one of the things that they did, the government did, was to translate every piece of legislation from English into Chinese. And under the IGCO, it was declared that the Chinese text, having gone through or approved by the Legislative Council, was then declared authentic, and indeed equally authentic, together with the English version. So let's once again look at the Chinese text of section 17. To break it down, it contains really two categories. First one, 任何人管有任何网拷或者其他为粗薄人身而制造的工具和物件。第二呢，任何手铐、指铐、攻击性武器等等等等，或其他适合做非法用途的工具。Now, if you look at the two categories that are written out in this way, you can see that in the second category, number 2, the Chinese version has lumped together or put together two very different types of instruments, i.e. those wrist restraints, handcuffs and so on, and those instruments that are used for housebreaking. And put them together and then followed by the words 或其他适合做非法用途的工具. So when you have two types of things that have no common element, that do not share a common characteristic, then the rule called that we've looked at, Justum Generis, cannot apply, because that only applies, if you remember, where there's a list of X, Y, and Z and other items, where X, Y, and Z belong to the same category. But now in the Chinese text, you can see that all those things in category 2 do not really belong to one category. And therefore, if one looks at the Chinese text, in this case, the Justum Generis rule did not apply. And that is really what drove the Court of Appeal to its wrong decision. Now, so how did the Court of Final Appeal deal with this linguistic issue? So first of all, it looked at section 10 of the IGCO. Now, it says that where a comparison of the authentic texts, i.e. the English and the Chinese text, discloses a meaning, a difference of meaning, which the rules of statutory interpretation ordinarily applicable do not resolve, the meaning which best reconciles the texts having regard to the object and purposes of the ordinance shall be adopted. So what this means is, let's try to reconcile the two versions using the ordinary rules of construction. But if that doesn't work, the court would then look at the object and purposes of the ordinance to decide which meaning best reconciles the two texts. Now, in this case, the Court of Final Appeal relied on this rule and rejected the Chinese translation. As we saw, the Chinese translation was adopted in 1993, much later than the original English text. So it looked at the history of the Chinese and English texts, and the court said that, well, because the provision had a long history and it was originally enacted in English all the way until 1993, when it was then translated into Chinese. And when the legislature provided that translation, it did not intend to change the law. So there was no evidence that the legislature had wanted to effect a change in the substance of the law. And therefore, it's the English version that prevailed. this is a very interesting case, at least to my mind, because it shows the range of tools that the courts use in order to arrive at a statutory interpretation. And let us take a moment to recap what those tools that the court have used in this case are. Now, we saw that the court of final appeal looks at the legislative history beginning from 1844. It also looked at the official statements of the government who promoted the various the original enactment and the subsequent amendments in order to find out or to ascertain the purpose and context of the current language. We also saw that the Court of Final Appeal applied the rule of construction called e justum generis. It also looked at the past decisions of the lower courts in order to find out how the courts have interpreted the provision in question. And they found out that that provision has always been interpreted according to the e justum generis rule. And then finally, it resolved the linguistic problem in that there was a difference between the Chinese text and the English text by reference to Section 10, the special rule laid down under that section in the IGCO. Okay, here we come to the third part of the presentation, and I will speed up a little bit, seeing that we're now at 6:34. So 第三个部分就是我想跟大家分享一下事实方面的分析。在普通法里面，我们用什么的技巧去分析这个证据，无论是文件呢或者证人的证据。Okay, so there are three types of evidence. So evidence that can be physical in nature. So for example, a gun or a note or a piece of paper. When we say a piece of paper, obviously it can also fall under the second category. If it's a document with written words on it. So documentary evidence is the second type. And the third type is, of course, witness testimony or witness evidence. In other words, the testimony of witnesses who attend court and tell the story. So the first two types of evidence are quite straightforward, but for today, I think we can focus on the third type of evidence. In other words, witness testimony, because it is something that is very special to the common law system. So when a witness gives evidence in court, he or she is supposed to tell the truth, the whole truth, and nothing but the truth. And that is the oath that a witness is still required to make, whether he or she is religious or not. So the examination of a witness consists of three parts. The first part is what we call examination in chief. That part is where the witness tells his own story under the guidance of the lawyer for his or her side. Okay, so it's a friendly type of examination. Now, I'm not going to, or time does not allow me to explain all the rules about examination in chief. But one of the major rules about examination in chief is that leading questions are not allowed. So what is a leading question? A leading question is a question that suggests the answer. Okay, so that's the main rule in in examination in chief, that the counsel, being a friendly lawyer, must not suggest the answer to the witness by asking a leading question. Now, after examination in chief, the counsel in question will then turn the witness over to the other side, to his opponent. The opponent's counsel will then conduct what is called a cross-examination of the witness. So the purpose of the cross-examination is directly contrary or contradictory to examination in chief. It is, as I will explain later, a chance for the opponent's lawyer to destroy the credibility of this witness. And when that is finished, there will be a final chance for the witness's side's lawyer to conduct what is called re-examination. So re-examination is confined to matters that arise from the previous cross-examination. And it is not a must, but some lawyers do it, but preferably they will keep it to a minimum. So once again, the rules about examination in chief apply to re-examination. Now, let me look at focus now for the next minute or so on cross-examination, because that is the major characteristic of common law systems. And that characteristic may be perhaps summarized by saying that in a common law system, the parties and the lawyers play an adversarial roles. So it is like a debate in every case. And the judge who sits in the middle is like a referee in a football match. The judge does not intervene unless it is necessary to clear up an answer and so on. And so he takes a neutral role and lets the two debating teams fight it out, okay, in the court. So because of this adversarial nature of the common law system, cross-examination is very important because it is the platform or the opportunity given to the opposite side to question the other side's witness. And the objectives of cross-examination are twofold. And the first one I've already mentioned is to destroy or to ruin the credibility of the other side's witness. And in so doing, the cross-examiner seeks to establish his own story or his own case to make it believable in the eyes of the judge or the jury. Now, I mentioned previously that leading questions are not allowed in the first stage, i.e. the examination in chief. But in cross-examination, the skill is completely opposite. The cross-examiner must ask leading questions, because by asking leading questions, the cross-examiner can put to the witness what his version of the events is. And so, but for the same reason, the cross-examiner must avoid asking open questions. So what is an open question? An open question is like, how are you? Or what did you think? Or where were you last night? So those are open questions. So what are leading questions? Were you, for example, were you in Shenzhen yesterday? So the answer must be yes or no. Or I could ask, you were sick, weren't you, with COVID last month? Okay, instead of asking, how are you? And the answer, again, is either yes or no. So by asking this type of leading and non-open questions, the cross-examiner will gradually push the witness into a corner and force the witness to agree with him. Now, one of the most important rules about cross-examination is that the cross-examiner has a duty to put his version of the events to the witness. So if the cross-examiner does not say that you are lying about your whereabouts last night, okay, if the cross-examiner wants to say that the witness had lied about that answer, it is something that he must give him or her an opportunity to rebut by asking him that question. So if the cross-examiner does not ask that question, then in closing submission, the counsel, cross-examiner, would not be allowed to suggest that the witness had lied about that particular matter. So that is all for cross-examination. So after hearing all the examination, all the questions and answers, then it's up to the court to decide on whether a witness is credible, i.e. believable, and whether he has lied or not in his testimony. Now, here I want to share with you the factors, the main factors that a judge would take into account when he or she is deciding whether a witness is credible or not. So there are 4 or 5 factors. I'll run through them quickly. The first one is what we call the inherent probabilities of each party's case. So when a version of or story is so incredible, contrary to common sense, the court is less likely to accept it as the truth. I think that is fairly obvious. And secondly, the court will look at whether there are aspects of a witness's story that is contradicted by other undisputed or indisputable evidence. And thirdly, the court will also see whether the witness has been lying about other things than the specific matter. So if the witness has been discredited about other aspects of his testimony, then he is less likely to be believed in respect of the main dispute. Now, we also looked at the other types of evidence, especially contemporaneous documents. So contemporaneous documents means those documents that were created before the dispute had arisen. So if a document, for example, a bank statement, was generated by a bank, there's usually very little reason to question the truthfulness of that document. And likewise, if someone writes in his diary a particular story, okay, years and years before the dispute has arisen, then the court may attach more weight to what he writes in the diary than what he says in the witness box, in case there's any discrepancy. So contemporaneous documents are very important because we often say that documents do not lie. Now, finally, some people who watch too much US courtroom drama may make the mistake of thinking that judges would rely on demeanor as a guide to the witness's credibility. This is not true. In our court system, it has been said many times that the way in which a witness performs in the witness box, in other words, his facial expressions, his tone of voice, or his body language, is not a satisfactory guide to deciding whether he is lying in the witness box. So a court will give more weight to the 4 other factors that we have just mentioned than to the last factor. Now, I want to briefly cover a rule which is about the failure to call evidence. Now, because in general, in a civil case at least, a party is free to choose whether to call evidence in terms of either witnesses or documents. And if a party decides not to call evidence on a particular issue, then the court may draw what is called an adverse inference from that omission to call evidence. Now, this is the case where, for example, a prima facie case has been already made out. In other words, an initial case has been made out, and the missing evidence is available to the party who chooses not to call it. And that party has no reasonable explanation why he chooses not to call that evidence. So if those three things apply, then it may be possible for the court to say that, well, the version of events put forward by that party must be rejected. Because if the missing evidence had been produced, that evidence would contradict the story that it wants to tell. So that is, in summary, what the rule on the first inferences says. Now, I think finally we have to cover very briefly the use of juries. Now, in most civil cases now in Hong Kong, they are not tried by jury. They are tried by a single judge sitting in the court of first instance. And it is very, very rare to allow a jury. In Hong Kong, a jury consists of 7 persons to sit together with a judge. Now, in criminal cases, the use of juries is more frequent, but it is still confined to very serious crimes, such as armed robbery, murders, rape, arson, and that kind of thing. Now, where there is a case with or a trial with a jury by jury, there is still a judge, and the judge and the jury perform different duties. The jury usually is entrusted with finding the facts. So whether a defendant was carrying drugs or not, or what the defendant was thinking when he was, or believed he was carrying when he was found with a drug on his body. So it's the jury who decides the facts. And on the other hand, the judge gives direction on the law to the jury, and he decides in a civil case the amount of damages on the facts as found by the jury. And in a criminal case, the judge would decide on the sentencing of the defendant who's convicted by the jury. So those are the brief points about the common law system. And I want to thank you again for listening.